it is very beautiful and wonderful to know that you're still staying glued to Starcross Television. Yes, it gives me great delight to welcome you to another episode, a wonderful episode of the Regnum Continuous Lego Education brought to you by Starcross Television. And of course, you know how we do it here. We are always ready and here to take you around the corridors of Lego practice. In case you haven't watched any of our programs, why not to tune into our station on any of your social media platforms like Facebook or YouTube and watch us. We have several and wonderful topics there for you to watch to abreast yourself. Remember, knowledge is powerful. I am Peace Smith, reaching out to you on Starcross Television. And on this episode, we will be looking at a very, very interesting topic. And we have another wonderful personality who will be doing justice to this topic. So make sure you stay glued, grab a pen, grab a paper, because today it is really a ride for knowledge. Stay tuned. We will be right back.
O King of Kings, Lord of Lords, Almighty and Divine, your glory shines like the morning sun, radiant and sublime. With reverence and awe, I bow before your majestic throne, eternal sovereign, ruler of all, forever enthroned. Your reign has captured the powers of all the world, religious practitioners, shaking the foundation of evil and making all tongues confess that you are the King of Kings and the Lord of Lords. Happy divine manifestation, King of Kings and Lord of Lords.
Let us rejoice, for our King all the
Welcome back. On your screen is Regnum Continuous Lego Education brought to you by Starcross Television. I am Peace Smith once again, and of course on this episode we will be looking at a very interesting topic. Let me start by asking you that who is your next of king here, or king? You know what I'm talking about. I mean, when you're going to bank, before you either open a bank account or something, or you're going for registration, an official registration for something, you're always asked for next of kin. So who is your next of kin? So we will be talking about it here. If you are a next of kin to someone else, or someone is a next of kin to you, today we will be looking at that, looking at the legal implications when we are talking about next of kin. So that forms the basics of our topic for this episode. Let me give you the topic the way it is. So the topic is legal issues in next of kin succession and inheritance. Let me take that again. Legal issues of next of kin, inheritance and succession. That is what we will be talking about today. This is a live broadcast. You can join us via our YouTube page and our Facebook page. please do well to join us in for the conversation. You can send in your comments, send in your questions, whatever you think. If you're a legal practitioner, please do well to feel engaged in whatever we'll be discussing today. So our discussant, who is right here with us in the studio, he will be doing most of the talking, and I will be learning and listening just like you. But not to worry, you will get the information as regards to this topic in a proper way. All right, so our discussant in the studio is Brother Kenneth A. Itoro Abasi Esquire. Brother Kenneth A. Itoro Abasi Esquire, good to have you here, sir. Welcome to the studio once again. It's been a long time.
Yeah.
How do you feel? How was the journey, coming from Akwa Ibom down here to Calabar?
Well, it's good to be here. The roads are getting better.
So
The roads are getting better by the day, and we have to first and foremost, thank God and the government for that.
All right, say hello to your audience. I mean, they've missed you.
Yes. Yeah, we had another duty still in the kingdom, which was choral. So now that we have the little chance, we have to be here. Good evening, viewers. Welcome to this important episode. We want you to stay glued and learn. And also teach us. Because, yes.
I love
so
the
you're
fact,
welcome.
Okay,
Yes.
I love the fact that you said the audience should also teach you and
yes.
teach me.
Yes.
All right, so today is going to be interaction. You talk, I talk. Now the topic is legal issues in next of kin, succession, and inheritance. Let's start with understanding the meaning behind, or the legal meaning behind next of kin. What does it really imply?
Yeah, next of kin is the closest relative to a person that may assume inheritance and some other rights and responsibilities. What we mean by that is that a person may be in a medical situation. Sometimes we travel, and by the time we are going, the passenger manifests on airlines, on the bus, and on the sea, high seas, whatever form of transportation. You find out that a manifest is given, and then right on that manifest said next of kin. It is just an emergency contact in the event that some form of liability arises or some form of benefit equally arises.
Okay.
But legally, it's generated by blood and legal ties. The person has to be that. What we are trying to say is that for you to be a next of kin, there must be that close relative, either the father or the son or the daughter or a cousin, but must be that kind of family blood relationship. Or if we talk about legal ties, we are looking at adoption. You know, there are some people that adopt children. And now these children come in not by blood. They rather come in by legal ties, because by the time you are adopting, there are certain forms, certain standard forms that you have to, a process that you have to go through in order to make that person, actually now being under your tutelage or being under your control or being in your group. So a next of kin is simply an emergency person that can be contacted in the case of medical emergency, in the case of a legal representation, and in the case of inheritance.
Okay.
Note that the next of kin is not yet an inheritor, but may be an inheritor.
Maybe,
yes. Depending on the circumstances. Yes.
All right, so let's look at the aspect of legal representation. So let's bring it to legal implication first. Let's understand that. What is the legal implication attached to being next of kin?
Yeah. The legal implication of being a next of kin is that the person may automatically become a decision maker. Okay. Like we're talking about a medical emergency. The man cannot take care of himself again. And then as a result of that, maybe the person is taken to the hospital. And then on that form, what we have to understand is that a next of kin in a particular situation may not be a next of kin in another situation.
What does that mean?
What it means is that if, for instance, someone is going to the hospital and then the form is given for him to fill, and he puts me as a next of kin, it doesn't mean I'm the person that is going to inherit his property, because I may well not be his next of kin in the office.
Wow.
Yes.
So where, at what point does it really stop? Because I feel when once someone is being said next of kin, that means that
Yes.
person has a right to that person's inheritance.
No,
Has a
no,
right
no,
to,
no.
for example, you're going to bank, you want to make, maybe you want to open an account or something, or make any financial transactions and all of
Yes.
that. You're being asked for next of kin.
Yes.
In a
And-
situations where you are not around
and,
that person. Okay,
and,
please
and, we,
help
and we are
us.
coming to all that because if you look
Okay.
at the case of Joseph and Faj Jemilehin 2012, it says the next of kin means a close relative or an emergency contact or a decision maker
Okay.
in certain circumstances. Being a next of kin is different from being an heir or a beneficiary.
Wow.
Yes, it's different. So what I'm trying to say is that it is situational. If I'm traveling from Uyo to Cross River State and I'm being given a form and I feel, you understand, and I put Peace Smith, it's for that for that circumstance, for that transaction. Once I arrive in Calabar, that transaction is over. Unless there is some form of benefit that is
Okay,
going to accrue
subject
to
to
me.
changes, okay.
Yes, that will accrue to me, and they have called my phone number or whatever contact I give, and they now say, okay, let's check who did he actually put, and then your name is there. It ends there.
Wow.
And then if I am also working in an establishment and they ask me for next of kin, I can actually put my uncle, I can put my wife, I can put my children. You understand? I can lump up in percentages. My wife take 40, my children, my 2 or 3 children take 30 or 20. You understand the situation? So what next of kin entails is that person, because the general notion is that once the person is a next of kin, once an issue comes up, he is the one that is going to claim.
Wow.
What we are saying is that it is situational. It depends on the circumstances. The man that took him to hospital might be a next of kin for the purposes of decision making, medical decision making. The one in the office might be the children. Don't forget that maybe the person was just traveling from Jerusalem to Jericho and had an accident, and somebody took him to hospital. And then at that point, if we look at the National Health Act, it says that immediate action should be taken on that person. So you now realize that at that point, maybe the blood relatives have not arrived, and then they say, okay, he should take a decision on behalf so that they can do this surgery, do that, take that action, take this action. He is only a next of kin for the purposes of that decision making. It doesn't mean that if any benefit accrues, that is the one to take it.
Wow.
Yes.
Okay, okay, please continue. I
So
have something.
now another aspect is that estate administration. The person may be actually be a next of kin for the purposes of administering an estate. Then he takes the legal action, begins the legal processes, maybe goes to court, he can collect debt, he can actually pay out outstanding liabilities from the estate of the deceased. He is just a legal representative. The real heirs may be the children.
Don't you think there could be some legal implications at that point as well, saying that, okay, for example, they're bringing different documents away from the succession document, and now you're seeing a different next of kin here, you're seeing a different next of kin here, you know, in 3 or 4 different documents, but related to just
that
one
means
person.
you didn't understand me.
Okay, please, let's
What I'm saying is that, for instance, I'm traveling from Yoto.
I understand that part.
Now, being a next of kin, being your next is an emergency contact.
Okay.
That in case I don't arrive in Calabar, call this person.
Okay.
It doesn't mean when it comes to from your own perspective, you are looking at succession.
Okay.
I want you to get the difference between succession, succession planning or succession plans, inheritance from the next of kin.
Okay.
The next of kin is the person that you meet. It can be from contractual, it can be by blood ties, it can be an adopted child, it can be a wife, it can be children. But what we are saying is that it depends on the situation. For instance, if I have estates, you understand, and I have named legal representative, that my legal representative is my next of kin. Okay. The person that will be contacted on emergency situation in the event of any issue arising. That does not mean that is the person that will pack away my property. By the time the legal representative administers that estate, he will now realize that I had instructed that my 3-bedroom flat should be given to my daughter. My car should be given to my brother. You understand? So those ones now are the successors. While it is the man that is the next of kin that is to facilitate the succession. Are you getting the difference?
Very well, very well.
So
very
that
well.
is the difference between next of kin.
Wow.
Are you getting it?
Very well.
Now, for instance, if there is a property, the next, next of kin issues officially, you find out that if the person is a minor, below the age of 18, it does not have, it's a dwelling capax. It does not have the capacity. But you now find out that the 3 children are the real inheritors of the wealth of that person. But because he doesn't have the capacity, those children don't have the capacity as at that time, under the law, to facilitate the process of getting that, then a person of majority, a person of majority is appointed as a next of kin to facilitate those gifts and give to the children.
Okay.
You understand?
Very
So,
well.
but at the end, at the same time, that person may equally be named as an inheritor
At that point.
inside the gift.
Okay.
That package, he may actually have what to get from it. But that does not mean that if he was just a next of kin, that is the one that will succeed into that estate.
Okay, thank
Yes.
you so much, sir.
Yes.
Because why I'm actually asking this question, a lot of persons out there, they
Yes.
sometimes misinterpret or mistake next of kin for successor. and
Okay.
all of
For
that.
instance, we were talking about the bank. You see, for instance, there is a form in the bank that we call pay on death. The person named is the person that actually the bank will actually give the money to. They will not give to any other person. But then that, for instance, if there is a letter of administration validly obtained by probate, you understand?
Yeah.
You now realize that by the time that is admitted to probate, whose name is on the letters of probate, on the letters of administration, Etomakpan, John Okun, Christopher Johnny, those are the inheritors. They are different from the next of kin, who is the person facilitating those gifts, those funds to be shared among.
All right, thank you
Yes.
for that clarity.
So that is the gymnastics involved in next of kin.
Okay.
It can, for medical reasons, it is just a decision maker.
Emergency.
The court, I mean, the hospital cannot just conduct the surgery. Somebody has to be there to sign, to take responsibility in the event of death. So that person is a next of kin for that purpose. Once the man gets well and gets back home, that contract is terminated. He signed that next of kin on the folder of that hospital. It may be different if he is working in that facility. Okay. Let's say University of Calabar Teaching Hospital. By the time they pick his employment form and check, that name on that hospital folder may not be the name on his employment form as next of kin.
All right, so now let's not dwell on that so much. Thank you so much, sir.
Right.
That was a very beautiful explanation. Like I said, a lot of persons return to mistake next of kin for a successor.
No. They are
inheritance
different.
and
They
all
are
of that,
different
or
things.
heir to an inheritance. Now let's look at succession now. What does
Yes.
it really mean? So that we will understand better to our audience watching right now.
Succession is the law that regulates inheritance of a property. You know, it's the act of taking over the rights and responsibilities under a will or some other testamentary instrument, including even what we call deathbed declaration.
Okay.
Somebody may not have a will. You know, when you're talking about succession, we are looking at tested succession and intested succession. Tested succession in the sense that the man has written down something and has been admitted to probate. Intested in the sense that the man has not written anything. Maybe at the point he was about that, he said, give that my house to my son. And let's assume he didn't mention the son, you know, at that point. Now, what will come in is, when it comes to tested succession, the law will play. For instance, the Marriage Act. But when it comes to intested succession, it is customary law. So now the customary law, give that my house to my son. Customary comes to play. Now let us look at a situation that the man has 3 children. what happens? Our own society is patrilineal. Patrilineal in the sense that it is the sons that will get it. And then there is the rule of primogeniture. Primogeniture. That rule, the rule of primogeniture, is simply that the first son holds in trust for the younger ones. So at that point, give down my house to my son. What comes to your mind? The first son.
Okay.
Because most African societies are patrilineal, and then there is the rule of primogeniture that applies. So, for instance, in the Igbo land, the man they call Opara, that is the first son. In the Ibibio, the man they call Akpan, that is the people that inherit the immediate property where the disease actually lived. Where the disease actually lived, they are the ones to inherit.
Okay.
Then if there are other properties, that is when the issue of sharing can come in. Let's assume that is the only property. Just where the man lived is the only property. That means that it is the first son that has the right of succession, that has the right of inheritance. But then out of goodwill, he may decide to share, if maybe there are little portions close to that property, to the other brothers and sisters, as the case may be. So that is primarily what the law of succession is saying. It's saying that it is based on intestacy, it is equally based on testacy. In the event that there was a will, there was a codicil, there was others, there was a bed declaration, then customary law comes into play. Now, if customary law comes into play, another issue that normally comes up is, what if the man is not living where he was born? What if he had moved to a place of domicile? He has changed his domicile.
Okay.
You know, we have the domicile of choice, you have the domicile of origin. Domicile of origin is actually where you come from. So the man takes his personal law, the customary law of his place is his personal law to wherever he's going. If you see the case of Bell and Kennedy, 1866, I think, Law Report, 1 Scottish Division, at page 307, it will tell you that the customary law of that person follows him unless he himself does an act, what we call the animus manendi, of changing that customary law to where he now resides. Otherwise, the customary law of the place where he is domicile of origin continues to...
I love the fact that, sorry, when
Okay,
you said that it is personal, that is customary law, he holds it in personal. Why am I saying so? Because, for example, you are in this place and you're living or guided by the law surrounding that, and you wrote your will as a person surrounding the law in that environment.
Yes.
And you decide to move to another place. And then, you know, in every setting, in every society, there is a law governing such a society.
Yes.
So now, this person going with his will, based on the customary law of where he was before, decides to change to wherever he is right
You
now.
are actually talking about the case of Olowu and Olowu, or unconsciously. That is what you are saying.
Okay, so
this man was a
issues like
Yoruba
that,
man. He was a Yoruba man. He changed his position to Benin. Benin, lived in Benin, had wives in Benin, married in under Benin law and custom.
Okay.
And then when the issue of succession came, they now said he was from Oshun, that they should now go back to Oshun and let that law of Oshun apply. But up to the Supreme Court said no, that this man had changed his personal law to Benin law, and that it is Benin law that will apply. The case of Olowu and Olowu is what you are talking.
Okay, so
and
we'll
I like
have
that.
to talk about it in elaborate. Please stay tuned, sir. All right, beloved viewer, let's take a short break. We will be right back.
And the Word was made flesh and dwelt among us, and we beheld his glory, the glory as of the only begotten Son of the Father, full of grace and truth. John chapter 1 verse 14. Behold, the divine mystery of eternity is fulfilled in this present generation. The eternal Word has taken flesh and dwells among men. In the fullness of divine time, the heavens bear witness, and the earth rejoices in the divine manifestation of the Father himself, the living Christ of all ages, the first begotten begotten of righteousness is holiness, Olumba Olumba Abu, the King of Kings and Lord of Lords. This year's glorious celebration is slated for Monday 17th through Sunday 23rd November 2025 at the Brotherhood of the Cross and Star World Headquarters, 34 Amber Street, Calabar, and in all BCS formations worldwide, with the theme The Word Made Flesh, celebrating the divine manifestation of the divine monarch. Highlights of event: Monday 10th through Tuesday 18th November 2025, special training on film making at BCS World Headquarters, Calabar. Saturday 15th November, general aerobics at Holy Mother Elizabeth Ultra Modern Redeemed Children's Home, Parliamentary, Calabar. Monday 17th November 2025, grand opening ceremony and homage visit to the Supreme and Incorruptible Judge, His Holiness Olumba Olumba Abu, by legal luminaries. Tuesday 18th November, open kitchen and official commissioning of the Brotherhood Model College ICT and Resource Center. Wednesday 19th November, global evangelism and humanitarian works soccer competition, special anointing, special heavenly renditions of songs heralding the divine manifestation by CNCF and Global Watch and Pray. Thursday 20th November, divine procession by the 144,000 virgins, 6 a.m. to 6 p.m. general fasting and the grand celebration of the divine manifestation, featuring presentation by the 3 promoted prestigious King Division choirs and empowerment of brethren by the First Royal Microfinance Bank Limited. Friday 21st November, consecration of the Christ Shepherds, BCS Choir Masters Conference and the exclusive pre-silver jubilee banquet with the Universal Monarch. Saturday 22nd November, March Past by BCS establishments and groups, special orientation for members of the International Organizing Committee and Local Organizing Committee for the Silver Jubilee of the King of Kings and Lord of Lords coronation. CNCF special moments with the Holy Father and singing competition. Sunday 23rd November, Thanksgiving service and grand finale, featuring the inauguration of the Silver Jubilee IOC and LOC and the unveiling of the leader Olumba Olumba Obu annual public lecture logo and lots more. For more inquiries, please contact Metri Christ Shepherd Princess Eddie Osisike, Chairperson, Program and Content Development Committee on +234 805 221 2210, or Petri Christ Shepherd Dr. Amma Williams, Chairman, Publicity Committee on +234 813 512 7355, and Petri Christ Shepherd Oga Osim, Chairman, BCS Event Management Board on +234 810 780 1980. Come, let us joyfully celebrate the living word, His Holiness Olumba Olumba Abu, the immortal King, unto whom be all honor, all power, and all glory forever and ever. Amen. Thank you, Father. Petri Christ Shepherd Michael Ibinabo West, Chairman, International Organizing Committee, Announcer.
For behold, cometh your King.
Welcome back and many thanks for staying tuned, like I said. All right, so we're still talking about issues, legal issues in next of kin succession and inheritance. So far, so good. From the little we have heard to this point, we understand that next of kin is not successor or is not heir to an inheritance. So I believe you had that clarity. If you did not, please take out time to watch up this particular episode again, and you will have something to thank God for staying tuned. All right, this is a live broadcast. You can join us via our YouTube page and of course our Facebook page. We are live. Please do well to join in the conversation. Remember, your first misunderstanding, how did they used to call it? Your first misconception has been cleared on this episode. Most of you would likely said or think that next of kin is synonymous to successor or heir to an inheritance, but it's not. So today we have all learned that. So we are still live, we are still progressing, and of course our very own resource person, Brother Kenneth, is still here with us, and we have a whole lot to ask him, permit me, to ask him on this episode. So make sure you don't go anywhere, stay glued, because we have a whole lot to learn. Welcome back, sir.
Yes.
Good to have you back. All right, so you were on succession.
Yes.
And of course, you said something about customary law as part of some of the legal issues, as part of some of the legal issues we face in succession.
Yes.
Now, let's look at it in broad or elaborately, while you also look at other legal issues surrounding the succession.
Yes, I think the first thing I want to do, I mentioned a case, I said Oluwo and Oluwo.
Yeah.
The citation is 1985 to Nigeria Weekly Law Report Part 13 at page 37.
Okay.
Now, we talked about the
Primogenitor
rule, that it is patrilineal and it is the first son. And then when it comes to, like in that case, in that Oluwo and Oluwo, you already painted the picture. The man is a Yoruba man.
And he
moves to Benin.
Okay.
To Benin.
Okay.
He lived in Benin, married in Benin, raised children in Benin, and then at the point of death, the family now said, let's go back to Oshun, where this man comes. And the up to the Supreme Court. Supreme Court said no, that this man had created a personal law, a personal customary law for himself. That goes in line with what I was trying to explain in Bell and Kennedy.
Yeah.
That the man has now exhibited and developed and established an animus manendi to be governed by the customary law of Benin. And so he had left. Now what happens? What happens as an addendum to that is that the lex situs, the law of the place where other properties are cited, is not affected. What we call the lex situs in law. That is what we mean by lex situs is, for instance, if I was the one that left Akwa Ibom and then went to Benin and I had properties in Akwa Ibom. It is the customary law of Akwa Ibom that applies to the properties that are in Akwa Ibom. Irrespective of the fact that I had moved to Benin, married there, you understand, had children, and upon intestacy it devolves. You know, the devolution is on Benin customary law. The properties I have in Akwa Ibom, it will be devolved on the customary law of Akwa Ibom State.
Why is it so?
Of Ibibio, if I'm an Ibibio man, of the Oron, if I'm an Oron man, or that is because the law of the place, what we call the lex situs, applies to those other properties. For instance, if I move now to America, and then I have properties there, the law that will be applied is the law of America, which is the law of the place.
When it comes to your succession.
When it comes to my succession.
Sharing of property.
Yes, then if I am from Akwa Ibom, the law of Akwa Ibom is what will apply to the properties that are in Akwa Ibom State.
Please let's understand. Let's have a clearer picture so that our audience will not be confused.
Okay.
Because I understand that you having a property, that's just a property. But who you are is governed by where you come from.
Yes.
Let me put it that way.
Yes,
so
you are right.
For example, I am an Akwa Ibom person.
Yes.
Now, I have a property in a, should I say, in a Yoruba country or land or whatever.
Okay.
Sorry, rather, in a Yoruba land.
Okay.
And now, it comes for succession or sharing. Do you think I'll be guided by the law of where my property is? Just like you said, I feel
depends
it's a
on
wrong
your
notion.
animus. It depends on your animus manendi.
Oh.
the permanent intention to reside is actually the animus manendi.
Because I feel it's my decision to choose.
That is it. You are right. It depends on your animus. That is why I say it depends on your animus manendi. If your animus manendi is that you have left your domicile of origin, you are now going to your domicile of choice. Just like we define in Bell and Kennedy. In fact, in that case of Bell and Kennedy, the man was a Jamaican. He moved to the UK. What we are now saying is that the law of UK applies to him if he develops or establishes an animus manendi to be his domicile of choice, which is UK. But what we are now saying is that, what about his properties in Jamaica? You understand? The law of UK will not, even if he has changed his animus, he has established a permanent intention to move from Jamaica to UK. The law of UK will not apply to the properties in Jamaica. Are you getting me? Wow. The law will only apply to the properties in UK, not the ones in Jamaica. The law of Jamaica is what will be applied in the sharing of his property in Jamaica. Are you not still getting it?
As interesting as this sounds, I still feel like there is still more clarity that needs to be done. Now, away from that, thank you so much, sir. I believe we
let me, in simple terms, let's leave legal jargon.
No, please do it, because I feel we need more clarity.
The man is an Efik person. You understand? He has moved from Efik land.
And went to another domicile.
And has gone to Akwa Ibom to live. And now, he married in Akwa Ibom, or has established a permanent intention to reside in Akwa Ibom. Are you getting the point? And then in the process, he acquires properties. What we are now saying is that when that property in Akwa Ibom is to be shared, it is the law of Akwa Ibom that will be applied. But now, let's assume that before he left Efik land to Akwa Ibom, he had properties in Akwa Ibom. I mean, in Efik. It is the law of Efik, which is the law of the place where that property is situated, which we call the lex situs, that will be applied to the one that is in Efik land. The law of Akwa Ibom cannot be now applied to the one of the properties. But as far as all the properties, if he didn't have any property in Efik by the time he left, the law of Akwa Ibom is what will apply to all his properties.
Okay, now let me bring your attention to, we have some countries sometimes who sign bilateral agreement on inheritance and succession. Now, in issues of still this law of domicile residence, where maybe you move to another place and you decide to, because you have properties that you decide to share and all of that. Now, let's say in a situation where maybe two countries involved. You are in this country and you decided to move to another country. And both countries have at some point had this bilateral agreement signed, which enables you to maybe let's bring in the issues of primogeniture to it. Maybe two countries have the same agreement on one thing. So how does this?
You are moving on parallel lines.
Okay.
You are looking at customary law, while this one is statute. And we have said that when it comes to statute, marriages, wills, that it is different. When we talk about the animus manendi, the law of, primogeniture, they are customary law. A customary law is a mirror of accepted usage. It is not a statute.
Okay, let's move to the statute.
Then if there is a statute, let's assume, if you now said, let's assume the woman got married. Now, that is the one I can talk about. If you say the woman got married under the law of US, it is the law of the United States that will now apply to all the properties that will be shared. But don't forget that the one that he had in Akwa Ibom, it is still the law of, the customary law of Akwa Ibom that will apply in that one.
Okay.
Are you getting my point? It is the customary law of Akwa Ibom that will apply in that one. Because that one was, it was not by way of statute. There is no law guiding, there is no written law guiding it. It is only a mirror of accepted usage that applies there. That is, that is the gymnastics behind this thing. So that at the end of the day, if, for instance, let me shock you. Let's assume that a man had only female children and all of them are married. You understand? Yeah. Those women are no longer entitled to the property of the man by virtue of marriage. A married woman loses her customary law. she loses it, and then is regulated by statute. But let's assume, let's take the ethic, customary law for instance. The woman can stay in the father's house, even be the head of the family. That is ethic, customary law I'm talking about now. Even be the head of the family, and then will beget children from outside, bring them. It is now this is children, her children, that will now come and succeed in that family. Are you getting the point? It is that, but let's assume that the woman now decides to go and get married. Maybe after the first birth, the second 3 children say, oh, what am I doing? Let me get married. She automatically loses the headship of the family, and she automatically loses the succession to that property. That is how it works. Now, when it comes to the Yoruba customary law, it is very simple. It is by blood. That means that the man and his children will inherit. The wife will not inherit. But now, what happens if the wife has property? It is, and then let's assume that she died without having offsprings. What happens? It is her own family, her own family that are entitled to that property, not the family of the man. Are you getting my point?
Well.
Not the family of the man. Now, a new dimension when it comes to marriages, a new dimension has been introduced, what we call the prenuptial agreements. Now, let's not forget that in the event of prenuptial agreements coming up with certain terms, clauses, and conditions, that may be seriously taken into consideration.
Let's understand the prenuptial agreement.
Prenuptial agreement is the agreement that a man and a woman reaches before marriage.
Okay.
The agreement might be that, look, in the event of a divorce, you only take what you brought and go back home.
Wow.
The prenuptial agreement can be in the event of divorce. That means a prenuptial agreement is a variation to the provisions of the Marriage Act, of the Lex Fori or the Lex Loci Celebrationis. That is the law of the place where that marriage was celebrated. So the prenuptial agreement comes into vary. Let's assume that they say that if in the event of a divorce, 50-50, the prenuptial agreement can come and vary it and say that in the event of it, you take 10%, I take 90%.
So what happens when each situation comes up, like the wife ends up taking 60%, or maybe these issues have been taken to court, maybe like the divorce case has been taken to court, and the wife is meant to go with, almost
That is when the prenuptial agreement comes in.
In situations like that, maybe there was no prenuptial
Yes,
agreement
if there was no prenuptial agreement, the provisions of the statute are strictly interpreted.
Okay.
They are strictly interpreted. But what was most important for us to discuss here was that the man, a woman that the father had her alone or had her with sisters, and all of them get married, they have lost the right
to their property.
So family, that man's property in the family stead. Unless if the man was wise enough, go buy land, put her name, put the second daughter's name, put the third daughter's name, say this is your land at Ikaika, that is your own at Afoka, that is your own at 8 miles. That property will devolve in succession on the persons named. Okay. Let's assume he made a will. After buying those properties, it will devolve on them. It cannot be taken from them. But when it comes to family property, which is guided by customary law, we say that they will lose those properties because of the fact that the African system is mainly patrilineal. Okay. But let's not forget about the provisions of Section 42 of the 1999 Constitution, which says that discrimination should, it's a fundamental right that you cannot discriminate against someone by virtue of circumstances of birth, and all that. You cannot, and the Supreme Court decision has been in that line, that even a female child can inherit based on the circumstances that we have drawn up, that a female child can inherit. Okay. For instance, if the property was bought, if the female child remains unmarried, you understand, if decides that, okay, for the sake of these properties, I'm going to remain unmarried, and then I will just go out and beget sons. What we are now saying is that those children will now be co-opted into the family property to become the heirs and the successors to that property.
Okay,
They will eventually inherit that property.
Okay, thank you so much, sir. We'll have to still go back to that. Okay. Yes, we have a question here from MC Eminence Laughter Hood. Yes, thank you so much for joining us on this program live or in our Facebook page. His question is, what if the couple is not from where the property is located? I think, yes, you have to do justice to that. Please answer the question.
So if the couple is not from where the property is situated, it will depend on the customary law of that place. For instance, in Akwa Ibom State, the customary law of Akwa Ibom State, as it relates to marriage, is that if they had accept to be regulated by customary law,
of that place
where
the property is
situated, yes. So it still boils down to what we say domicile of choice. The animus manendi established of a permanent intention to reside and be governed by the law of that place. I can't remember the section, but if you look at the customary laws, 2022 of Akwa Ibom, it clearly stated that if the couple consent to being governed by the customary law of, so even if they got married in Owerri under Igbo customary law, they can actually come to the customary court of Akwa Ibom State and their issue can be settled, including the devolution of property. It can actually be settled by the customary court of Akwa Ibom State. But what is needed is their consent, which we will translate to what we call the animus manendi, or the permanent intention to be governed by that law.
Okay.
Yes.
All right. Thank you so much. Yes. I believe Eminence Laughter Hood or MC Eminence, whichever way, I believe you're satisfied with the explanation so far. But if you're not, please do well to still send in your comments. Brother Kenneth here, he's here to do justice to your questions. I can see every other person. Please permit me to also acknowledge them so that they will also know that we are doing something here. Please send in your questions. We are ready for your questions and for your comments as well. Starting with Sister Gladys Onyebo. Thank you, most wonderful Abba Father, for being our greatest defender and advocate. There is no one like thee, leader Olumba Obu, the only true friend of man. Yes, of course. From Smart Sam, good and very nice. And from Brother Eminence, thank you, Father. Okay, so that's all we have. That's all we have. Please do well to all of you watching. We appreciate you. Please do well to send in your comment, because this is a topic that bothers on you and to someone sitting very close to you today. If you don't have a king, next of kin today, trust me, something will arise that you need one tomorrow. If you have not done your will or your succession will, something someday or somewhere, you will definitely need that or do that or be faced with that. So do well to send in your topic or your questions and your comments. Please, we have Barrister here to do justice to that. Okay, I can actually see Eminence saying, thank you, sir. I appreciate. That means he's satisfied with what you said so far. Now, let's look at inheritance. Let's look at some of the legal issues as per inheritance.
Yes, I think before we go into that inheritance, I would like to give the case for the married persons, the situation the married persons will face. We have the case of Obuze and Obuze 2007 10 Nigeria Weekly Law Report, part 1043 at page 430. Now, inheritance is very simple. It is the devolution of property on an heir upon the death of the owner.
Okay.
But in the case of God, because we are going to look at it, that God will not die. You understand? He never dies. He lives forever and ever. We will look at that situation differently. But then let's look at a situation where the man, the property is now devolving. Now, there is actually no clear-cut difference between succession and inheritance. Succession is the mode of getting the inheritance.
Okay.
Succession is simply the mode of getting the
process, or
the process of getting the inheritance. So
okay.
It's that is succession. So, and the important thing about succession and inheritance is that it helps to develop future leaders and helps to keep the wealth of the family within check. You understand? If, let's assume that the man made a will and the will says give to the man in Calabar, give to the man in Lagos. You know that the family property is going out. But let's look at situation, normal situation, the premonigenitor rule, which says that the first son, it is now the first son that comes in to control the property, and then the property devolves on other members of the family through the first son. And then that property stays within the family. You understand? Now, if we go down, we'll find out that the Supreme Court have in a long line of cases held that any customary law which is inconsistent with any law in force, which is contrary to good conscience, contrary to equity and good conscience, that it should not be upheld. We have the case of Ukeja, it is 2014 law report electronic, 2014 law report electronic, legal pedia electronic law report, sorry.
Okay.
Then we also have the case of Anekwe and Enekwe. We have the case of Mojeku against Mojeku with Mojeku, and Mojeku is 2004 11 Nigeria Weekly Law Report, part 883 at page 196. You understand? That says that a customary law that allows only males to exercise right of inheritance is unconstitutional and discriminatory. However, it is very important to note that a female member of that is married loses. That's what we are doing. We mentioned the case of Buze and Obuze. We are looking at Anekwe and Enekwe, where the supremacy of the constitution involving discriminatory succession was upheld. Now, the legal importance of inheritance lies in the orderly transfer of the assets.
Okay, can you explain that?
Yes, what we mean is that let's assume the first son says I'm the owner, the second son says am I not the child of the family, and then at the end of the day the fight will